This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when an incompetent insurance fraud perpetrator presents a claim that results in his conviction and then tries to get out of it with some silly motions because he had pawned the jewelry that was the subject of his claim and then claimed it stolen, only to find that the state of New Hampshire decided to issue a search warrant that resulted in finding the pawned jewelry as well as one sitting in his house. The defendant, Vincent Cheney, appealed 2 orders from the Superior Court denying motions to suppress and for a new trial. In State of New Hampshire versus Vincent Cheney, the Supreme Court of New Hampshire on May 3, 2024, resolved this dispute over Cheney's conviction. In 2018, Cheney traveled to Florida and purchased 3 pieces of jewelry. One, a necklace worth $63,138. Hereinafter the large necklace. 2, a necklace worth $4,500, the small necklace. And 3, a bracelet worth $16,050. Following the purchase, the defendant, Cheney, took out an insurance policy with Phoenix Insurance Company, also known as Travelers, on all 3 pieces of jewelry. Cheney filed an insurance claim with Travelers for the small necklace and the bracelet. Travelers paid the claim in March, and in May, the defendant filed a second claim with Travelers Insurance, alleging that the large necklace had been stolen during an armed robbery in Boston. Travelers ultimately denied the second claim due to the defendant's non-cooperation and referred the case to the New Hampshire Insurance Department, indicating that it believed the insurance claim to be suspicious. During the state's investigation, the investigator learned that Castro, Mr. Cheney's girlfriend, had twice pawned a bracelet identical to the one reported missing in the first insurance claim. At the time of the investigation, the bracelet remained in the pawn shop. In December of 2019, the investigator interviewed Ms. Castro, who lived with Cheney after he obtained approval for a one-party intercept in order to record the interview. Castro described the 3 pieces of jewelry and alleged that they were all missing or stolen. She stated that she had an older bracelet at her house similar to the one that went missing, but that she had never insured the older bracelet due to its age. She also stated that she had never pawned the older bracelet. Of course, jewelry doesn't get less valuable with age. If anything, it gets more valuable. But Castro then changed her story and stated that the bracelet at the pawn shop was the older bracelet that she previously claimed was at her house. After that, the interview ended. She just left. After obtaining a warrant, the state's search discovered drugs, drug paraphernalia, multiple firearms, and one of the missing necklaces. The defendant was subsequently charged with possession of a controlled substance with intent to sell and numerous counts of being a felon in possession of a deadly weapon. The defendant was separately charged with 3 counts of insurance fraud in connection with the claims he made to Travelers Insurance. To suppress evidence seized under a search warrant, the Supreme Court noted that the defendant must show that the misrepresentations in the supporting affidavit were material and were made intentionally or recklessly. Materiality is determined by whether, if the omitted statements were included, there would be still a case of probable cause sufficient for a search warrant. Finally, the court found that although the defendant's assertion that the investigator, rather than Castro, initiated the termination of the interview was mostly accurate, the Supreme Court agreed with the trial court's well-reasoned and thorough opinion that the affidavit supporting the search warrant did not contain any material omissions or misrepresentations that rendered the warrant invalid. The task of the issuing court is to make a practical, common-sense decision whether, given all the circumstances set forth in the affidavit for a search warrant before it, including veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. The reviewing court may consider only the information that the police brought to the issuing court's attention. Neither the issuing court nor the reviewing court could have considered the 2005 receipt when determining probable cause, regardless of the claims of Mr. Cheney, and any alleged error in not attempting to introduce it at the suppression hearing did not prejudice the defendant's case. The order was affirmed, and Mr. Cheney's conviction stood affirmed. In my opinion, Mr. Cheney was involved in an amateurish attempt at insurance fraud by reporting the theft of jewelry that he had pawned, a fact easy for police agency to establish, but difficult for an insurer to determine, and that's why they paid his first claim. Cheney was caught when the pawned jewelry was found by a state investigator. A search warrant was obtained, and the police not only found in his residence one of the so-called stolen items, plus drugs sufficient to arrest him as a drug dealer as well as a perpetrator of insurance fraud. He tried to claim the warrants were improper, and the Supreme Court refused his claims because they had no basis in fact or law. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and access to the more than 4,750 blog posts. You can also subscribe to the videos on Rumble and YouTube, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on Rumble. And if you're interested in receiving further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.